let's proceed with focus on health law. To maintain a good standard of living, I agree, one should follow diet and exercise rules. But, on the other hand, one must follow the rules of the patient-doctor relationship. Bearing that in mind, let's hear all about the doctor-patient contract presented here by attorney Kenneth Haber, who is a practicing attorney in Boyds, Maryland. To question attorney Haber, here is attorney Ramesh Khurana of the Khurana Law Firm from Gaithersburg, Maryland.
Welcome to the Capital Forum. This is Ramesh Khurana, attorney at law. I have my office in Gaithersburg, Maryland. Today I am really privileged to have a very experienced attorney, attorney Kenneth Haber. Welcome to our studio.
Thank you, Ramesh.
Kenneth is the former assistant U.S. attorney and also the former senior attorney in the Office of Inspector General. Very experienced and knowledgeable about healthcare laws. I know that many physicians have taken advantage of his competence in this matter. And today I am going to ask you some questions. I know that in the last segment we talked about physician-patient contracts, and you were kind enough to answer some of the important questions. So we continue with the same concept of doctor-patient contract. Now tell me, what is the purpose of a doctor-patient contract?
Okay. The last doctor-patient contract we're talking about dealt with controlled substances and the doctor-patient relationship within that context. The fact of the matter is that there's other things that doctors do with patients other than deal with controlled substances, and the doctor-patient contract in general, which is different than the controlled substance one, is defining the parameters of responsibilities of each, the doctor and the patient, and setting out what's expected of each. This is aside from, in addition to, the contract that they have that the patient's supposed to pay the doctor, which is also a concept that some doctors don't want to take insurance, and they might very well have a doctor-patient contract that specifies they're not taking insurance, and that they'll just give the patient a receipt that the patient can, file for reimbursement from the insurance company as far as whatever the insurance company will pay the patient, because the fact that certain type of practices, the insurance companies push against. They like traditional practices, and anything that's not traditional, the insurance companies just resist all over the place.
Okay. Now, Ken, we know that in any contract, termination clause is always very important. So when we are talking about a contract by a physician with a patient, can the contracts provide for its termination clause?
It certainly can. Patient, of course, can always terminate the doctor's services.
Rather, I would say that patient can always fire his doctor.
Absolutely,
right?
Absolutely.
They can always fire their lawyers.
That's true too.
Patient is the king.
The patient is the king.
Right.
But the fact of the matter is the doctor wants to be able to fire the patient as well.
Right, yeah.
And they want to be able to do it where the patient can't claim abandonment. Normally a doctor is supposed to give a patient at least 30 days notice if they're going to be terminating the patient.
When you are talking about a 30-day notice, whether this has to be a written notice or it can be an oral notice?
It's best if it's in writing, so that the patient can't deny it, that it exists. And the doctor wants in his doctor-patient relationship in writing certain provisions, and failure to comply with these provisions could result in termination. The doctor may very well want in his contract with the patient that if the patient doesn't abide by the doctor's suggested treatment regime, that the doctor has an opportunity to terminate the patient. Now, just because the patient doesn't want to follow a doctor's advice doesn't mean every time that happens the doctor's going to terminate him, because there wouldn't be any patients sticking around with the doctors. But there could be such critical areas. for that patient's health care. The doctor doesn't want to accept and continue the responsibility of treating that patient if the patient doesn't follow the doctor's advice, because of the fact that it is so critical. And the doctor would rather the patient go elsewhere, so the doctor doesn't end up getting sued because of the patient not following the doctor's advice.
Now, that is very well explained. Now, let me ask you one more question. Now, during the course of medical treatment of a patient, a doctor may come across a situation where he or she has to provide non-covered services. Now, can he provide in the contract, which is to be signed by the doctor and the patient, that patient will be responsible for payment of non-covered services?
Yes, certainly can. Now, the doctor normally accepts the patient's insurance. The doctor should provide the patient with a document called Advance Beneficiary Notice of Non-Coverage, so that the patient is aware of this. It's required by Medicare when doctor has a Medicare patient and the doctor is accepting Medicare.
So that's mandatory in
That's
case
mandatory.
of a Medicare patient.
But a doctor should do that with regular insurances to give the patient notice that this is not covered for several reasons. One, it makes it more easy to collect from the patient,
Right.
because the patient isn't surprised.
Meeting of minds.
It's a meeting of minds,
Right.
exactly. So there'll be less complaints later on. If there is a complaint later on, here's the piece of paper where I notified the patient that it wasn't covered.
All professionals have a difficult challenge of managing clients' or patients' expectations.
Absolutely.
Yeah, so this is one of the factors where we have got to be very careful.
Absolutely.
Yeah.
Now, if the doctor's just not accepting insurance at all, not accepting programs, it should be in that contract, which is signed by the patient, so the patient can't later come and complain that the doctor's not doing it, because once again, the doctor has a piece of paper that the patient knows that the doctor is not accepting insurance or accepting, the programs. That still doesn't alleviate certain problems for that doctor if the doctor is on Medicare's bad boy list. If the doctor is excluded and the doctor knows that patient, is a Medicare patient, that doctor cannot normally treat that patient and expect the patient to be able to turn around and bill Medicare. Because Medicare won't pay for that if the patient's aware of it, and they can't try to get around that by just pretending the patient's not aware of it. There's a whole, it's not just a single presentation, but there are all sorts of consequences by being on the exclusion list of of healthcare providers that are excluded from Medicare. But one of them is that the patient cannot turn around and bill Medicare. There's an exception to that, and that's if it's an emergency type of situation. And under the exclusion rules, that if it's a single type of situation, that's permitted for emergency type of purpose.
Now, let us stay within the contracts when you are suggesting that all the important provisions should be incorporated in the contract. The question is, although it's a kind of pre-printed contracts and there are some fine prints as well, so what's the obligation of the physician to make the patient conversant, or at least he should create a situation whereby the patient makes a well-informed decision about the various clauses in the contract? Is it the job of the doctor to make sure there is a proper meeting of minds?
Well, the contract should be clear so that the patient does have an understanding, as long as the patient, has a reasonable intelligence quota. If the patient has some sort of impairment, then whoever is responsible for that patient should certainly be informed, and if the patient's a minor, then their guardian should be informed of what those terms and conditions are. I have a child that's a special needs child, and some doctors will accept government programs and others will not. And there has to be a meeting of the minds, and there are, and some you will, reject because there are other doctors who can provide the same service, and other doctors provide such a rare service that you just pay out of pocket and you just accept it as such.
Okay. Now let us change the subject a little bit. Now tell me, why does a practice become a cash based practice?
Well, normally they become a cash-based practice is because the payers who would otherwise pay are giving the doctors so much grief and aggravation that the doctor doesn't feel it's worthwhile. And that's, I think, the primary driving force for doctors to go into a cash-based situation. People who have Lyme disease find it very difficult to get any doctors who take insurance programs because of the fact there's such aggravation about it. The medical establishment does not want to recognize Lyme being as pervasive as it is, but just a couple years ago, the CDC came out and changed their estimate of 30,000 new outbreaks, new incidences of Lyme, and made it 300,000. Lyme, unfortunately, does not have a good test in terms of defining who's got Lyme and who doesn't. But there's other type of practices that are niche practices because of the fact that insurance programs don't want to pay for it. Some pain management practices have to go cash because of the fact that insurance companies in their area don't want to pay for pain management. There's a number of those things that come up where insurance companies just don't want to recognize things, which the doctors do, and forces the doctor to go to a cash basis.
Very interesting. Now, can just tell us what type of medicine practices do insurance companies resist payment to?
These type of niche practices like the Lyme, like pain management. It's interesting because of the fact that if you've got Lyme and you recognize you've got Lyme and you have pain, and you know you have pain because you're feeling it, you'll go to a doctor wherever he is and you'll pay whatever you need to pay in order to get it taken care of. And that doesn't mean that the doctors are exploiting you. They might very well be charging a regular rate for you, but the insurance companies don't want to pay it.
Yeah. Now, again, coming back to the contract issue, we know that we talked about the meeting of minds in contracts and about the meeting of patients' expectations when you have good contracts between the physicians and patients. Do you think that if the contracts are properly signed by the doctors and patients, they might reduce basically the chances of medical or malpractice suits?
Yes, because one of the provisions you can have in your contract if you're a doctor, unless it goes against your own state's ethic rules, is an arbitration clause. And if you have an arbitration clause in there, mandatory arbitration clause, attorneys, malpractice attorneys for the most part, are not going to be all that interested in taking the case. And even if that clause were to be subsequently struck down, the malpractice attorneys don't want to, who are working on contingency basis, don't want to have to go through a long contested litigation as to whether or not that provision is accepted in the state in order to find out if they're going to get paid or not. So just that one clause would help keep away, malpractice suits.
Okay. Now let me ask you a quick question. You're talking about the arbitration clause in the contract, and patient says that I was never informed and this was not my well-informed decision that my dispute is subject to the arbitration clause and he challenges that very provision. Can he do so?
Sure, he can challenge it, but chances are he's not going to get an attorney who's going to want to take the case to challenge it on a contingency basis, you know, because of the fact that it's going to cost a lot of money to litigate that type of situation.
Got it. Thank you very much, Ken. Again, your answers to my questions were, I'm sure, very beneficial to the audience. Thank you very much for
My
coming
pleasure.
to our studio.
Thank you.
Hopefully, we will meet soon to talk about certain more subjects. Thank you
you.
so much. Thank you, audience, for being with us.